Hello and welcome to this great Law Week 2022 event on judges and juries. I'm Lynn Holte and I'm the Executive Director of the Victoria Law Foundation. And before I introduce you to our speakers this afternoon, I'd like to acknowledge the traditional custodians of the land wherever you may be joining us from. This afternoon I'm on Bunurong country and I pay my profound respects to their elders and to all First Nations people, and to acknowledge also that these lands were never ceded. At the Victoria Law Foundation, we recognise the impact of colonisation, its legacy in injustice and the marginalisation of Torres Strait Islander and Aboriginal peoples across the country. And we believe that acknowledging that past is an essential step in building a better and more equitable future. At the VLF, we are genuinely committed to making a contribution to a better justice system for all of us, but particularly those who are vulnerable and most in need. And just a few little housekeeping matters to keep everything straight. Because this is a webinar format, your mics and your cameras will be off for the duration. And if you are having any technical problems, put those in the chat function and we'll see what we can do to address those as we go. But just reserve the Q&A function for your questions. So we will have time at the end, we hope, for some contributions from you. So please put your questions in the Q&A or upvote other people's questions that you would like to hear the answer to. And at the end, we will absolutely be sending you a video of this recording this afternoon. So if you've missed any or you'd like to visit it again, then never fear, we'll send you the video in a link in the next few days. So, judges and juries, I know you're going to find this session very interesting and engaging. It'll give you some really terrific insights into our legal system and how judges and juries and courts work together in practice. We'll also hear about what's happened over the last couple of years in terms of the impact of COVID on the courts, and for some time now also the impact of the internet and what that does to the judge and jury process. Our two presenters today are Jane Patrick and Paul Dorr, and we are very delighted to have them both with us. Jane is a retired county court judge and Paul is the Juries Commissioner of Victoria. Jane was a county court judge for 10 years and she specialised in crime, and before that she was a magistrate for 8. So she has very extensive experience on the bench. After studying law, Jane worked as a legal studies teacher. So not only has she got an extraordinary length of service and experience as a judge, but she knows what young people need and want to know. So I think she's got a really brilliant perspective for you today. And welcome to Paul Dorr, our Juries Commissioner, who, as you will hear very shortly, if you're not aware of Paul's presence till now, is a Canadian. He came to Australia in 1994 and he's worked in a number of senior operational and policy roles, first in the youth justice system in Victoria and now with courts and tribunals. Was the CEO of the Supreme Court of Victoria, rather the COO, the Chief Operating Officer, for 5 years, and he's been the Juries Commissioner for the last 10. So we're going to hear from both of them in turn, and then we'll have opportunity for a discussion between them after that. So don't forget your questions if you hear something through their presentations that you'd like to pick up at the end. But without further ado, let's get this show on the road, and I'd like to introduce you to Jane Patrick.
Thank you very much, Lynn, and hello to Lynn and Paul. It's great to be here talking to you today about judges and juries. When I was appointed as a county court judge in 2008, I knew I would be sitting in crime and that I would be in charge of jury trials. I knew that 12 randomly selected impartial people would make a decision on the facts in the trials that I would be conducting. Now, I had been a practitioner in a few trials before I was appointed as a magistrate or a judge. I knew a little bit about the history of juries. The origins of juries are lost in the mists of time, and some sources say they came from Germany and others say they came from France. In any event, in 1066, William the Conqueror brought the use of juries to England. although some elements of the jury system may have already been part of the Anglo-Saxon culture. So it's all a bit uncertain, but it starts from around about 1066. By the 1100s, jurors in England had to be free and property owners, which meant they were actually knights. Sheriffs went out into the countryside and found jurors who knew about the facts of the case, either from first-hand knowledge or from hearsay, and who could give evidence to the justices about the case. So jurors had to know something about the facts of the case or about the general circumstances or context of the case. It's a bit different now. Up until 1219, trials, this is in England, could be trials by ordeal of fire or water, or by battle or by oath. The Catholic Church then forbade trials by ordeal, and then later they said there had to be battle or a jury until 1268. And eventually it all changed so that all trials became by jury rather than by ordeal or battle. The idea of an impartial jury to hear evidence, to listen to evidence from other people, was developed. And by the late 1700s, the modern jury system of selecting by ballot from a list of men who met the property qualifications was instituted. So it was men only, and they had to be property owners. When Australia was colonised from Britain, the ideas about juries came with those colonists to Australia, but it took some time for the early settlers, the early white settlers, to develop the idea of juries and what to do about juries and the use of juries in Australia. In 1901, Section 80 of the Australian Constitution provided, this is at the time of federation when we no longer were just separate states or colonies, but when we were made all one in Australia in 1901, the Australian Constitution said that in trials for indictable offences against any law of the Commonwealth, there was a right to be tried by jury. The first trial by jury in Victoria happened in 1839, and because Victoria was effectively part of New South Wales then, it was under New South Wales law, a man was charged with stealing a pair of trousers with a shilling in the pocket. He was found not guilty by reason of insanity, and that was the first jury trial. Now, as Lynn has said, I was a magistrate before I was a judge, and in the magistrates' court, I dealt with summary crime and indictable crime. I've mentioned indictable crime and the right to a trial by jury for indictable crime. Now, in the magistrates' court, the magistrates deal with summary crime, which is a lower level offending, but they also deal with some indictable crimes where the accused consents to have the matter dealt with in the magistrates' court. So, for example, theft is an indictable offence. The maximum penalty is 10 years imprisonment. You can imagine that some thefts are really small, just a small amount of money or something from a shop, or say a bottle of grog from the grog shop, something like that. Any of those kinds of things can be small, or it could be thousands and thousands or millions of dollars. But where it's small, even though it's still an indictable offence, if the accused person consents, then the matter can be dealt with in the magistrates' court. And there are lots and lots of indictable offences dealt with in the magistrates' court because the accused consents. If the accused doesn't consent, then the accused can go to the county court and have a trial by jury, because that's the accused's right. So my first real responsibility for a jury came when I was appointed as a judge to the County Court of Victoria. I sat only in crime for 10 years in the county court, so I subsequently learned a lot more about juries and what juries do and don't do, and how judges should work with juries to make sure that trials are fair and conducted in accordance with the law. There are occasional jury trials in civil proceedings in the county court, but because I only sat in crime, I'm going to stick to talking about crime and jury in criminal trials. Now, when it came to the first criminal trial I did as a judge, the accused was charged with obtaining property by deception. His wife was overseas and he sold a house belonging to his wife, and the prosecution case was that he'd sold that using a false power of attorney. So that was what the trial was about. If I could have the picture, Helen. Now, when I went into court, I'm going to have a picture in a minute which shows you a courtroom, but when I went into court, there in the courtroom were court staff, juries commissioners staff, practitioners, the accused in the dock at the back of the court, and about 40 people who were part of the jury panel. Now, out of those 40 people, there were going to be 12 people selected to be on the jury. I'd done some reading and I talked to other judges in preparation and worked on my empanelment script. That's what judges say to the jury panel before and during the jury selection process. It's an explanation to the jury of what the trial is about and what their role in the trial is. They're told that they are judges of the facts and that they must be objective and unbiased. So thank you, Helen. We have a picture of a courtroom. This is a courtroom in Bendigo. And this picture is taken from the dock. That's where the accused sit at the back of the court. And you can see there are a lot of chairs there. There's the jury box on the right, the witness box on the left, and there's the judge. That's me at the back or at the front, depending which way you look at it, and the associate and tip staff and the bar table. Now, you can't in that picture actually see all the chairs in the court. There are a lot of chairs, but when I came into a courtroom like that, all of those chairs, their chairs a bit further behind and to the right and to the left, would all be full of people waiting to see if they were going to be empanelled on the jury. So in the empanelment process, having explained all those things to the jury about what their role is, what the case is about, then I would hear excuses. So this is when people would say that they wanted to be excused from being on the jury, and they would just stand up in the courtroom and say, I want to be excused, and I would ask them why. And they might say something like, you've told us now that this case is going to go for 2 weeks and we thought it was only going to go for 5 days, and I have my sister's wedding in Brisbane next week. So I'd say, yes, thank you, you were excused. And this would go on. Usually you would get maybe 4 to 5 to maybe 10 people asking to be excused. Sometimes people would ask to be excused because they said that they would not be able to be unbiased because of the subject matter of the proceeding. Sometimes people would want to write down what their excuse was, and then that would be handed up to me because they didn't want to say it in front of everybody. Generally, people were excused, but not necessarily. Once all the excuses had been dealt with, then there would be the challenges. So the associate would stand up with a box and have all of the names or numbers of the juries and their occupations on a card, on individual cards in that box, shake the box and pull out cards and call them out. The person would stand up and walk around in front of the dock and around so that the person in the dock, the accused person, could see them and would have their right to challenge them, would have 3 challenges. They could just say, I don't like your look of you, or I don't like your occupation, and would challenge them. And then they would have to go back and sit down. Once the person was not challenged and sat down in the jury box, then they were part of the 12 people in the jury. So these 12 people would decide the facts of the case and apply the law that I told them to apply those facts. And by doing that, to decide whether the accused was guilty or not guilty of the offence charged. If they were guilty, it was up to me to sentence them. Thank you. If we could have the picture off now. Thank you. Now, it was my job, apart from sentencing people, to make sure that the trial was fair and conducted in accordance with the law, and to tell the jury, to direct the jury about the relevant law that they needed to apply in the proceedings and in order to make their decision. So first of all, at the beginning of the trial, after they'd been empanelled, then they would be given preliminary directions. Amongst those preliminary directions was a very strong direction telling them that they were not allowed to look up anything about the case or anything to do with the people involved in the case or the subject matter of the case or the law involved in the case. and they were not allowed to look up anything about any of those things on the internet or anywhere else, social media, etc. They were told that it was a criminal offence to do so, and that the penalties could be applied if it were found out that they had looked up anything like that. They were also told that there were reasons for this, and that the reasons included the fact that they could look things up and they would know something, but the judge and the defence barristers and the prosecution barristers wouldn't know what they had looked up, and so wouldn't be able to say anything about it, and that would not be fair. Jury trials are run, criminal trials are run with very strict rules about what evidence can and can't be given. Juries are told that they must base their decision on the evidence presented to them in court and on no other basis. They're also told that this used to be easy in the old days. You'd have to go to a library to find out anything, but nowadays, of course, everybody's used to looking up everything automatically and immediately. But juries can't do that. And there have been a number of trials where the juries have had to be discharged. So the trials have to start again because jurors have looked up things on the internet. Juries are also given directions by the judge in the course of the trial about what evidence is admissible, not admissible, how they can use certain evidence and so on. And at the end, the judge has to sum up all of the parts of the law that the jury needs to know in order to make their decision, and to tell them how those parts of the law relate to the evidence that's been presented in the trial and the issues that there are in the trial, what the prosecution and defence are arguing about. In a lot of trials, there's a lot of evidence that goes through unchallenged because those facts are not disagreed with by either side. But there are certain points where the facts may be disagreed with, which raises an issue, and the jury needs to decide those facts, and they need to understand the law that they need to apply. It's all a very big responsibility, as you can imagine. Now, what I didn't know anything much at all about was how those 40 people, that whole courtroom full of people, came to be there. I knew they'd get there, but I didn't know how they were there, and I didn't know why they were there. Now, the person who can tell us all about that, and also some of the impacts of more recent events such as COVID, which I haven't had to deal with, fortunately, is Paul Dorr, Mr. Paul Dorr, the Juries Commissioner for Victoria. So over to you, Paul. Thank you.
Thanks very much, Jane. The short answer to your question, how did those 40 people get into the room, is this: the Juries Act. The Juries Act guides the work of the Juries Commissioner's office. So the Juries Act says there shall be a Juries Commissioner and as many Deputy Juries Commissioners as is required to administer the Act. The Act is predominantly focuses on all the activity that needs to occur to allow those 40 people to get into the courtroom. So the Act has got a purpose that says that we provide for the operation and administration of a system of trial by jury that equitably spreads the obligation of jury service amongst the community and makes juries representative of that community. It also, the third purpose of the Act, which will make no sense to our audience, says that it allows for allows us to adopt technology to administer the Act, which when it was written as a bill in the late 1990s and came into effect in the year 2000, technologies were emerging, whereas now technology is, you're all natives of technology. So there are some historic aspects or elements of the Juries Act that I quite frankly, and I think Jane would agree, need to be reviewed in light of society, the way the community expectations in 2022. You've touched on technology as it relates to doing your own research. Well, the Act actually says you can't do your own research, and then in brackets it says including using electronic databases or something, which is code for Googling. But when Parliament wrote it, it was funky stuff, where now it's just everyday technology. So your question also around where did those 40 people come from is you aren't the first judge to think that. You haven't been the last judge to think that. And as recently as last week, I was talking to a newly appointed judge who asked the exact same question. So it always amazes me. One of the really good parts of my role is that I contribute to the induction program of new judges appointed to the court, and we've gone from sort of a paper-based presentation by the Juries Commissioner to an interactive experience where I insist, as much as I'm allowed to insist that a judge do something, I request that the judge meet me here in my office in the jury pool room, and we start at the counter and we walk into the pool room, and we right into where there might be 150 people sitting waiting to be randomly selected from the pool to go up into your courtroom, Jane, as part of the panel. So it's a really good experience for me, and it just never ceases to amaze me that these very, very, very experienced prosecutors or barristers, criminal barristers, would say, I never knew this existed. And I would tongue-in-cheek say, where did you think those 40 people came from? And the answer is always the same. I never had to think about it. My job as a barrister or a prosecutor was, to defend my client or prosecute the trial. And I knew I had to work with 12 people, but I didn't really care where the 40 came from. So the 40 people come from the work that my office does, and we have really two primary tasks that are captured in the Act. The first is to assess the eligibility and the availability of citizens who are liable for jury service. You're liable for jury service if you are on the electoral roll, the Victorian electoral roll, and given voting is compulsory, most people in the community are on the electoral roll. So that's our first primary task: assess the eligibility and availability of people who have been randomly selected. And the second is to deliver groups of 40 people to individual courtrooms when judges want to start a trial and they require a jury panel to allow them to do the in-court selection oversee the selection of 12 that Jane described, listen to excuses, oversee the challenging and the stand aside sort of process. So our work is both administrative and at times factory-like, and also it's very, very personal. So how do I say this? We randomly select, we ask the electoral commissioner to randomly select upwards of 200,000 people a year across Victoria. And if you would ask my staff, it feels sometimes like we are having a one-to-one relationship with every one of those citizens randomly selected. Part of the reason it feels like that is that most people in our community haven't done jury service. So most people, what they know of jury service is what they've seen on American TV, which is doing a massive disservice to the jury system in Victoria, because don't believe everything you see on TV. And secondly, the American system of trial by jury is significantly different than that in Victoria and Australia. So we feel like sometimes we are dealing with people who have a good reason to be excused or maybe ineligible for jury service, and we're assessing those on a quite honestly, it feels like a one-to-one basis. Now, to be fair, of those, I'll take the 200,000 random selected. Every couple of months in the Melbourne district, we'll say we need 10,000 names or 15,000 names. We have a jury management system that allows people to go online and lodge, answer the questions in the questionnaire that goes out with the notice of selection. And a lot of people can do that without ever having to talk to us. So if you live more than 50 kilometers from the courtroom, you've got a right under the Act to apply to be excused. You just tick that box. Google Maps in the background tells us, and it automatically excuses you. We don't even know that you were randomly selected. There's no upper age limit on jury service, but we say if you're 70 or over, if you want to be excused, you can be excused. And if you go online and do it that way, it registers your birthday, and it just, it magically just gets you off our list. So, but we then have to deal. So I'll step back for a second. We randomly select people in that role. It's called a jury role. And from that, we ask people to answer sort of three basic questions. Unfortunately, it takes us about 4 pages to ask those 3 basic questions, but tell us a little bit about what your occupation is, so that, because there's a number of occupations in the Juries Act that makes you ineligible for jury service. Tell us whether you've been before a court and sentenced to anything, and we'll tell you whether your past criminal activity makes you disqualified from jury service. And I'll just say very quickly, if you've been sentenced to anything in the last 2 years by a court, you're disqualified. If in the last 5 years you've been sentenced to something that resulted in 3 months or less of prison time, then you're out. In the last 10 years, you've done something that put you in prison for up to 3 years, you're out. And if ever you've committed murder, treason, or been sentenced to more than 3 years in prison, you're out. So we assess whether we ask you a bit about your occupation, determine that you're eligible. A little bit of, so most people are eligible and most people are disqualified. But then we give you an opportunity to tell us anything you want about your circumstances that you may want to apply to be excused. And that's where the one-to-one feeling comes. So the Act sets out a couple of prescriptive circumstances. Distance from the court, you can be excused, but then the rest are subjective. Financial hardship and inconvenience and things. So we have to make assessments. Our job really is to make sure that those 40 people that go into Jane's courtroom, Judge Patrick's courtroom, aren't going to waste her time or the court's time applying to be excused for reasons that they could have been excused by us. If you're self-employed, if you have the care of children or other family members during business hours, if you're traveling, if you've got a medical reason, any of those should be dealt by us, including the length of the trial. And I'll just say that everything we say to jurors leading up to going into that courtroom is that the average length of a trial is 2 weeks. So please have 2 weeks available. There's every chance that you might show up and you're in a courtroom that's got a trial that's going to start and will only run 3 days. That's great. You've just saved 7 days out of your calendar. But equally, if a trial is going to be 4 months, we have a process whereby we can vet is the wrong word, but we can exclude people from the pool based on the length of the trial, so that we only have people going into Judge Patrick's courtroom. Those people are available for that length of time, so she doesn't have to hear the very obvious reasons. I've got a plane ticket to New York or a hip replacement on June 7th, and I can't do those. I can't do that trial. So a big part of our work is busting myths, because I said that American TV has done a huge disservice. There are two main differences between the Victorian system, the Australian system, and the American system. One is around juror anonymity. Jane's already said, you know, that the ballot cards go in with a ballot number, a panel number, and occupation. That's all. That's all the court. That's all the judge, the lawyers, the other jurors, the accused. That's all they'll know about you, is maybe your name, but 99% of the time it's your panel number and your occupation. Whereas in the States, you know, they've got that sort of celebrity thing where everybody becomes a superstar for 15 minutes in their life. And and equally, they have a process in court called voir dire, where there's a lot more questioning of prospective jurors. Well, there is questioning of prospective jurors, where there's no questioning of prospective jurors in Victoria. So that's one big difference. And the other is that jurors in Victoria, it's against the law for them to talk about their deliberations and to particularly publish their deliberations. And it's against the law to publish an image or any information that can identify a juror going into for jury service. Whereas again, in the States, you know, you can write a book, you can do a documentary as a juror. You know, Oprah was a juror. She did a whole show about jury service, brought the other 11 jurors onto her show. They talked about, you know, all sorts of things about the trial, where, you know, you would just be put in jail here in Victoria if you did that. So those are the two big differences, and that's the myth busting aspect of our job. So people will get randomly selected and all of a sudden go, you know, I don't want to be on TV. I don't want to be put in danger. You know, I don't want to, you know, and you think, don't believe it, don't believe it, don't believe it. I don't want to lose money. You don't lose money. Your employer is obliged to make up your pay. So, you know, there's just a lot of myth busting on our part. So our role very quickly, we assess the eligibility of those randomly selected. From those people who are eligible and available, we send out summonses. That gives a batch of summonses. We will send out maybe 800 for a week in Melbourne, 400 on a Monday, 350 on a Wednesday, another 150 on a Friday, so that's 900. But it gives a person an opportunity to apply to be excused or deferred again. And our experience is that that people are a lot more focused when they get a summons than they are when they get a notice of selection, because it's actually saying we want you next Monday. And from those people who attend, they attend the pool, maybe a group of 100, 120, we might have 5 or 6 trials starting that day. And from that group in the pool, we randomly select other smaller groups of 30 or 40 to go in the courtroom. So that's how they get there, Jane. It's really simple. I'll say very, very quickly, the state of Victoria is divided into 14 jury districts. Melbourne's one, 13 regionals. So we replicate that process in every district, and certainly judges will go on circuit. So, you know, so you would have, did you like circuit as much as the judges that are?
Yeah,
I think circuit's a fun part of the.
I like circuit.
You know,
it's hard work. You better add that. But it's very interesting, and it's different sometimes. It's different in different parts. I mainly went to Bendigo and more Latrobe Valley, but you can go to all different parts. It was interesting. Yeah. And so you got to mix around with people more.
Yeah, exactly. And we have staff in each of those regional districts, and they work really closely with judges and judges' staff who are coming on circuit. Judges will be on circuit for maybe 4-week blocks, maybe sometimes 6-week blocks. So that's us. That's how we interact with the courts.
Excellent. Well, thank you to you both for that sort of really useful sketch of your two different roles in this process, which come together in in the courtroom. But I'd love to hear some questions from our audience. So if you've got anything, put it in the Q&A and we'll get to it in a minute. But meanwhile, back at the ranch, I have lots of questions for both of you. Jane, you mentioned at the top that, that there are certainly circumstances where juries have had to be dismissed because one or other of them has done a bit of Googling or research on the side. Did you ever have that experience yourself where you had to dismiss a jury?
No, no, I never did. I did do a trial, which was the fourth time that the trial had been run, and one of the reasons, so this was the fourth, but one of the reasons one of those juries was discharged was because a juror had done that. So it's not all that common. Paul would probably know better than I do. It's not all that common, but it does happen. And the judge found out about it because the person told some of the other jurors, and the foreperson of the jury did the right thing and told the judge, through the judge's tipstaff, told the judge that's what had happened. And then the judge called the person in and asked them about it.
So probably, exactly that question, how common is that?
Yeah, well, the issue is we don't know, because we only know when exactly that happens, that somebody tells somebody else, and then the group kind of says, we're not supposed to do that, and then reports it to the judge. We've got about a half a dozen of them right now bubbling along in the back, like that have been dismissed. And what happens is that 9 times out of 10, I then have to refer that to Victoria Police to investigate that good citizen who showed up to do jury service. Now they're getting investigated for breaching the Juries Act. There was one that you saw in Bendigo or Ballarat in the last couple of weeks, was in the news. So I'll just tell you what was in the news. Allegedly, the person went to the campground where the sexual assault had happened at 4:30 in the morning and was testing the lighting at 4:30 in the, doing these things because he probably thought he was helping. And he's watched 12 Angry Men far too many times, and just thought, if I could do my own investigation, I could help the court,
So
I think it's totally understandable. I remember once I was doing a trial of it was a driving that had caused a death, and I couldn't work out from what the evidence was really what that intersection was like. So I thought, I'll go and have a look. And I thought, no, first of all, I'm not on the jury. And secondly of all, the jury are told they're not to conduct their own investigation. So what am I doing? I didn't do it, but,
Yeah. Look, I did hear a judge once say that the first thing that judge was tempted to do was Google as soon as they got the trial, because they thought, and then he said, I'm allowed to, but yeah, I don't, but I'm allowed to, but jurors aren't, they just, and we really have to, the royal, everyone, we really have to get our comms right, because it doesn't, it's counterintuitive to the way we now do things, right? Whenever we're having a conversation, we grab our phone and say, oh, wait a minute, what would, I had a friend just, I'm texting him, he lives in Atlanta, and he was just saying, we're talking about hockey, and he just said, do you think we're going to have a replay of the 96 Stanley Cup series? And I said to him, tell me who played, because I don't have time to Google, but I could have just Googled it and got my answer, right? So it's what you said earlier, Jane, that whatever that information is has to be tested in court. All parties have to know what it is. The internet's static, not, so what we say to jurors when we're telling them not to Google is, we're saying, you pretend you're at a tennis match. You're just listening back and forth and weighing up things. Don't go find your own information.
So it is.
One last thing I'll say is that everyone who's done it, I can't think of anyone who did it maliciously. They all thought they were helping. Yeah. They all thought they were helping the process, helping the judge, helping. Yeah.
I mean, there's some interesting questions there about the effectiveness of the prosecution or the defence in terms of painting the picture strongly enough so that, for example, with the intersection that you were talking about, Jane, or giving enough, evidence and pictures and all that kind of stuff to help juries see it in their minds without having to do their own driving research at 4:30 in the morning or whatever. But I mean, you mentioned earlier that the concern here is that members of juries have information that cannot be refuted or tested in any way by the defence or the prosecution in court, because they don't know what the juries have unearthed. But is it also, and going back to the sort of 12 angry jurors circumstance, is it also about making sure that jurors, one or more doing their own digging, can't unduly influence their fellow jurors? Is that a factor that is borne in mind here, Paul or Jane?
Well, I'd defer to Jane.
I don't think so, because it's really more to do with the fact that nobody knows what it is. The judge can't give them directions as to whether that evidence is admissible, not admissible. The prosecution defence can't make submissions as to how the jury should look at it. Whether there is one juror who has an extraordinary influence on the other jurors is a problem that the juries have to deal with, the jurors in that jury have to deal with. If they can't, if it becomes so upsetting that they can't possibly manage or whatever, then they have to speak to the judge effectively through the tipstaff, and the judge will talk to them and see and the judge can tell them, you've all got to listen to each other, and it's sort of, there are directions about you've all got to listen to each other, be respectful, etc., etc. But there is nothing to prevent one very persuasive juror persuading other jurors to their point of view. And in fact, someone I knew told me that that's what they'd done. They said with great pride, and this was a person who was a lawyer, Paul, later, and said, I was on a jury and I knew that person was guilty and the other 11 weren't so convinced. So I told them that they were wrong and I told them why, and I convinced them.
Wow.
And that happens. Yeah. I'm sure it happens. There's nothing we can do about it. And the jury have to kind of deal with it. Because in the end, they have, as a group, they have to come to that conclusion. Are they satisfied beyond reasonable doubt, all 12 of them or 11 or whatever it happens to be, of the guilt of this person?
Yeah. And I could say one of the other bits jurors aren't allowed to do is to seek counsel outside the other 11, right? So go out, phone a friend or that kind of thing. And we had one recently, and it's always the self-monitoring, the group monitored, like whenever it becomes evident that somebody's doing the wrong thing, it's always because the rest of them kind of said, you're doing the wrong thing and we are telling on you. Like I don't know if people have tolerated the bad behavior. And we had one, again, don't have to give too much detail, but it was very clear that this one juror had sought advice from his partner, his wife, because these jurors said to the judge, he was just talking like this for 4 days. And then he came back and he actually said, I've discussed it with my wife and now I think this. And, so he was bringing outside information into the deliberation room, and they all said, that's wrong. You've been told you can't do that. And they told on him, the judge, So I think most times they get it right. They respect it, but there's the times where,
and they do take it very, they do take it very seriously.
They take it too serious. Yeah, they take it so serious that they think they're helping, and they end up really. And we remind people, $35,000 a day to run a criminal trial, so you don't want to be disrupted. If you're a taxpayer, you don't want to be
messing that up. So when you mentioned earlier, Paul, that, you have to get VicPol involved if it arises that somebody is in breach of the Juries Act. We've got a question about what's the maximum penalty, or what happens to you if you found to have breached the Juries Act. Do you know?
I do. Doing your own research, the penalty it's 120 penalty units, and a penalty unit I've got it. I write it every year on my Juries Act is $181. So 181 times 120, maybe $17,000 or
Yeah.
about. If you breach the Juries Act, if you're found to have breached the Juries Act in that the secrecy of the deliberations, there actually is prison time. Like a judge can sentence, and if you don't honor a summons, if you don't show up, if you're impaneled on a jury and then without good reason show up, you can go before a court. Again, we're not a prosecuting agency, so I would refer it on to either Victoria Police or VGSO to the Victorian Government Solicitor's Office to. So you can Google Slattery v. the Juries Commissioner v. Slattery, which was a man who basically told us in 2017, get stuffed, I'm not coming in for jury service. And we took it to court, and it went to the Supreme Court. And Justice Jack Forrest said, it's very serious, and I'm thinking I'm going to jail you if you don't give us a good reason. And he ended up getting 80 hours of community work and $2,000 fine.
Yeah, don't mess with the Juries Act.
Well, no, and we're not. We are very, very, very. We are not like that. Like I have to tell you, in New South Wales, they fine. Like if you don't show up, they just push a button, and you're fined. But the problem with that is, most of the fines then are for. Most of the absences are for good reason, like the person never got the summons or they moved 3 years ago. So the fine has to go and get undone. So the red tape is just not worth it. We are very, very accommodating. Judges would probably be not happy with how accommodating we are. Like we really work with citizens to make sure that they can honor their summons. It just happened that this guy actually said, how much is the fine? Great, fine me. Now, so we took it to court.
Yeah,
like he made a commercial decision.
Yes,
like
yes,
he could afford the fine, and that's great.
Yeah, but it was important to make the point. Yeah. Jane, you mentioned also, the summary that a judge needs to make at the end of a trial in order to give the jurors their instructions about, what they're then going to go and deliberate on, and that consists of the law that they're there to apply, the various acts or parts of that they need to think about in relation to the facts. That sounds like a fairly complicated process to put that all together in a way that is both comprehensive in terms of what they've lived through in the courtroom, and clear for a juror to understand and then to take away to the room. Do you spend a lot of time as a judge putting together that summary?
Yes, it varies from judge to judge, but it's one of the things you're thinking about from the beginning of the trial to the end. So you're making sort of notes to yourself, or you might even be making a document. There are some parts of what you tell them that are routine, in the sense that all juries will be told certain of these things. And there are certain things that you have to tell them again, which you've already told them, such as the elements of the offence. So that students will know that to prove an offence, the prosecution has to prove the elements, the essential ingredients of the offence beyond reasonable doubt. So you would be telling them in that you tell them the elements of the offence. But you really only need to tell them the law that matters to the particular issues in the case. So for example, if you've got a theft trial, theft is the dishonest appropriation of property belonging to another with the intention of depriving the other permanently of it. Now, in a lot of cases, you might, for example, so all those are the elements of the offence the prosecution has to prove. You might get a case where it is agreed that the accused took this item, but the accused said, I thought I was entitled to take it and therefore I'm not dishonest. So the only issue might end up being dishonesty. So you need to tell the jury the law about dishonesty. How is dishonesty defined in our legal system? Which is basically you don't have a belief in a legal claim of right. to the item. That's in Victoria. It's different in different places. But that's what you would be telling the jury about, and you would tell them about that in the light of the evidence that's been given in the trial. What's the evidence that relates to that issue? And you'd summarise that. So that sounds not too bad, and it's not too bad. The difficulty comes when you've got multiple offences with multiple different elements and multiple alternative charges. Now, I won't go into the technicalities of that, but it becomes very technical, which is why you don't, in the end, it's difficult to have indictments if there are too many counts or charges on the indictment and of two different nature. So it's quite tricky. And the other thing we use now is checklists a lot. So it's a checklist that you give to juries saying, did he take it? Yes. Go to question 2.
Right.
If he didn't take it, he's not guilty. That's that sort of thing. Well, I did one where I had 95 questions because there were multiple charges, on drug importation and things. But, anyway, doesn't make anything easier. Maybe if we haven't addressed the issue of a COVID and judge alone trial.
Yes.
So maybe judges alone might find it easier. I don't know.
Well, let's quickly go to that because we're moving on in time. But Paul, you've been working through this whole period, and the courts have certainly had major challenges in terms of continuing to operate through the COVID period. And as Jane's alluded, the part of the response has been to provide judge-only trials, so no juries. So what sort of impact has COVID had? And are we going to go back to normal, or are we going to end up with a hybrid, do you think?
I think we're going to end up with a hybrid. Well, both. We are back to normal, but there is a hybrid model emerging, and that's so when we were first coming out of COVID in late 2020, the legislation was
the first
changed
time.
One of 6 coming out. The legislation was changed to allow for a judge alone trial. That sunsetted in, I think I'm right, around 30 June of 21, because the assumption was we were going to be out. It's since been reinstated, and I don't know if there is a sunset clause on it, but my understanding is that it's now reinstated, not so much because we want to minimize groups coming together, but if it's allowing the courts to get through the backlog that's been established, then maybe it could be quicker to run. So there have been a number of judge alone trials. Our job is clearly to work with listings and see what's on the horizon, and it's now not uncommon for us to get a notification that says it's gone to a judge alone trial. Uncommon by like maybe a dozen in the last few months, not hundreds, and certainly during COVID we changed everything. So all our processes were all that notice of selection, summonsing, all that assessment, pools, managing pools was all done virtually. And we only brought in the 30 or 35 people that Judge Patrick needed for that one trial that was starting. And we kept them separated in a big pool room and video linked into the courtroom. So only the 12 people actually ended up in the courtroom. All the challenges and excuses were heard remotely. Places like Scotland have introduced movie theaters where the jury's sitting 4 blocks away in a vacant theater while the trials running. The Victorian judges wanted no part of that, and I'm happy they didn't. So yeah, turned upside down, and now really the biggest thing, and this is a county court story, and the chief judge, if you Google or could just go on the county court's website, you'll see the backlog is what is keeping judges awake. So there are more listings in 2022. I mentioned those jury districts. It used to be Melbourne, a full-time district, Geelong, Morwell, sort of 80% full-time, Bairnsdale, hardly ever. Now it's almost full-time work across all districts, and they're listing to judicial and courtroom capacity here. They're just whenever there's an empty courtroom, get another judge in there and another
Yeah.
jury. And so we did some stats. I don't want to bore you with it, but we're the first quarter of 2022 was anywhere from 50 to 80% busier, or more money spent on more jurors and everything than any other first quarter of any other year since Magna Carta.
You're
I don't know about
breaking
Magna Carta. No, I don't know about Magna Carta, but since 2015, you know what I mean? In the last 10
long
years.
time. Yeah. Jane, we'll need to wrap up in a sec, but I'm interested now that, you know, we've raised the whole judge only or judge alone cases, and I've become aware that they, you know, pop up now and again in various different jurisdictions. But in Victoria, for a criminal offence where a jury would normally be impanelled, are there reasons why, or what are the reasons why you might go ahead outside of COVID and needing to deal with the backlog? Are there other reasons that trigger judge alone trials?
I can't really speak from actual direct experience myself. Some of what I'm going to say is what I think, and also observations as to what occurs in other states where they've had the ability to have judge alone trials. So COVID and the need to try and progress trials through has obviously made a difference. There have been some other arguments, particularly in high profile cases, which have attracted a lot of publicity, that potentially there might be difficulties getting jurors, particularly if the crime occurred in a rural area or somewhere where you have got a limited sort of population pool and everybody's going to know about it, so that perhaps having a judge from outside or interstate even might make a difference, and that's happened in some cases. There is another line of thinking that judges, whether alone or is in the panel, might be better able to absorb highly technical information than jurors. I'm not entirely convinced about that. I think good experts and good barristers are very good at presenting quite complicated material in a way, if I can understand it, then juries are going to be able to understand it broadly, because I'm not particularly technical. But I can imagine there might be some case where that might be thought to be advantageous, particularly where you are trying to do a jury trial where you've got conflicting expert evidence, but you want to do one of these hot tubbing of experts. That is, you put the experts together to get the experts to discuss between themselves in front of the judge what their arguments for and against various things are. A judge will presumably, maybe, able to distinguish between what's admissible evidence and what's just discussion, what are conclusions, what's just argument, and so forth, than a jury might be able to, which might speed things up if you want to do that. The other, I think, this is a personal view, that probably that it is not against the interests of the defence. So the accused person doesn't necessarily get any less fairness if it's a judge alone. Because I think overall, and this is just partly as a result of my work as a magistrate, thinking of being a judge of fact and law then, that possibly judges who are legally trained might be more focused on a technical legal argument and give the benefit of the doubt of that to an accused rather than concentrating on the facts as much as juries do. Juries are very practical. They bring, and they're told to bring, their common sense and life experience to the trial, and they do, which is why I think overall they're a better proposition than judges alone, myself. And I think it's important because of the community involvement and people being judged by their peers and the responsibility for heavy decisions to be shared amongst the community like that. That's my personal opinion.
And that's what we tell jurors when they're concerned that they don't know the technical. We say, don't worry about it. You're not meant to. It'll be explained to you, and just bring your common sense, and 12 of you will arrive at a decision, not one Jane or one Paul, but so I think it's pretty powerful.
Well, I think on that very positive note about the power of juries and jurors, it's a perfect moment to wrap this discussion. But thank you to you both so much for being part of this conversation and part of Law Week in 2022. Jane Patrick and Paul Dorr, our esteemed presenters on judges and juries this afternoon. We hope very much that you've enjoyed it and learnt a lot about the interaction between judges and juries and how we get the justice that we do, and that we all have a very fine afternoon. Thanks again for coming.
Thank you.
Thanks, Lynn.